approve the minutes. So we'll just move on to the number 2 item on the bill, or on the agenda, committee bill ritual abuse amendments. We've got Representative Birkeland and Representative Ivory here to talk about it. So representatives.
Thank you so much for your time this morning. I think we have talked about this issue a few times now, and so I'll try to be brief in what I share. This is a very important piece of legislation. What this bill does, with the input of the committee, is it makes sure that ritual abuse is codified in state law. This will help law enforcement understand and get trained on how to handle those who have been victimized by ritual abuse. It will help mental health therapists. It will help everyone in treating and caring for those individuals who are victims to this. So that's a very important element to it, because they need to be seen, they need to be heard. We need to recognize that this does happen in the state of Utah. It also changes the enhancements, essentially. It allows for them to, the judge to rule. What we don't want, what we didn't like, and when I talked to many of you committee members, the fact that someone could injure, rape, abuse someone hundreds and hundreds and hundreds of times and get 5 counts, and then at sentencing, they just were let out. They just only got hit with 5. They could be sent out early. That was wrong. And it shouldn't be that way. And now with this bill, the Board of Pardons and Parole can look at this and see, oh, this involves ritual abuse. It was real, it happened. And they can make a more informed decision at that point. So I'll just turn a few minutes over to Representative Ivory to share.
Thank you, Representative Birkeland and Mr. Chairman. I think this really exemplifies the best of the legislative process. We brought a bill in, we had ideas that came from constituents, my constituents, and then others came in. And then as we presented to the committee, wonderful members on the committee, Representative Birkeland, Representative Abbott in particular. So we think we can make this even better, and bless their hearts, on their own, they put a great deal of time in and met with a number of stakeholders and courts and Board of Pardons and Paroles and others. And I am really pleased with where this bill has landed. And significantly, what this does is it is very trauma-informed, victim-centric. The way we had the bill before, a victim would have to be in direct examination, in cross-examination, and having suffered the type of abuse and to be then subject to cross-examination would be a tremendously difficult task for anyone, let alone someone that's been through the type of trauma that you've heard, just unspeakable trauma. And so it is such an elegant solution that they have worked on and come up with, and we've met with victim and survivor groups and others and had broad support across those groups. And so, Mr. Chairman, I really think this is a great example of the legislative process in action, and couldn't be more thrilled. And on behalf of many of the survivors, victims, and others, really want to thank the committee for the work that they've done on this, particularly Representative Birkeland, Representative Abbott.
Yeah, I would just like to echo that. Representative Abbott was a key player in getting this drafted as well. So thank him very much.
Thank you. Appreciate that presentation. I know we've heard this issue going back to last session a few times. So appreciate the work that you put in on this. We'll go ahead and bring it back to the committee for further discussion. Representative Abbott, you look like you want to say something.
I'll make a motion that we favorably recommend this.
So we're going to hold off on that motion for a second, because I believe there's some people from the public that would like to speak to this. But when we get there, we'll come back to you.
Okay.
Okay, we'll open this to public comment. Because of the nature of our committee today, we do have quite a few items on the agenda. We want to limit comment to 2 minutes per person. So if you'd like to make a comment on this, please come up. We'll ask you to state your name, the organization that you're with, if any, and go ahead and present your testimony.
Okay, thank you. My name is Jason Randall. I'm a lieutenant with Utah County Sheriff's Office. I supervised our Special Victims Unit for 10 plus years at this point. At this point, I supervise our entire Investigations Bureau. I'm also here on behalf of my sheriff, Sheriff Mike Smith, who's the outgoing president of the Utah Sheriff's Association. We've been involved with this bill since pretty close to the beginning. This bill does have the support of the Sheriff's Association as well as Sheriff Mike Smith. I've spoken in front of this committee before, as well as the other committees. This bill is vital for the victims. It sends a very clear message that they are being heard. On a personal level, as far as my role with the Sheriff's Office, we are still involved in multiple investigations regarding the very issues that this bill addresses. This investigation has been ongoing for almost 4+ years now, and it is still ongoing. And so I have personal knowledge of some of the tragedies that have occurred of this. So most importantly, every time I've been in front of the committee, there have been questions, people that were not sure, and other issues. So if you guys have any questions from the law enforcement side, I'm all ears and be willing to answer any questions you have. But that being said, again, this bill is vital, and absolutely needs to be passed.
Thank you. Appreciate that. Are there others from? Yeah, come on up.
I don't know where to look. I just thank you for your investigation. This is the type of thing that fizzles out so drastically fast. I know Homeland Security was involved in investigating for over 8 years, and they terminated their investigation because multiple factors, of which I'm not privy to, but it is a difficult thing. I just want to thank you to be here supporting this bill, and for all of you who have contributed to it. Thank you, Representative Birkeland and Abbott, Representative Ivory, Kara, Brett, and all who have put your heart and passion into this. This is a kind of a dark horse, something that is not pleasant on any level, but it's so vitally important. And I speak for myself, for lives tragically lost to these abuses, and also for those who are still held captive in the darkness of these traumas, who do not know that they have a voice, who do not know that they have recourse, that do not know that there are people fighting for them. And I want to represent that full range where there are people who've lost this fight, but there are still people fighting. And it is incredible to have people fighting with us. This bill is critically important as a first step to raise awareness of what ritualistic abuse is, to identify perpetrators and their behavior, develop sustainable help for victims, as Representative Ivory mentioned, and ultimately prosecute those who are guilty of these crimes, allowing those who have been ravaged by such abuse to safely step into the light, to find freedom and healing. My hope is that this incredible state of Utah, that I still choose to call home, will put perpetrators on notice. We need victims. We will find you. These crimes will not happen on our watch. And I am forever changed by the opportunity to rub shoulders with all of you, to see this process in motion, see that there is heart and soul involved in this work. It's just an incredible honor and a restoration of my hope and faith in the goodness of humanity to be able to work on this with you. Thank you.
Can we ask you to state your name?
Sorry. Yes, Kimberly Rhea Cohen.
Thank you. Welcome.
Thank you. Good morning. I'm Kara Baldry. Any opportunity to stand up for any child who knows the horrors of any form of abuse is a win for humanity. The opposite is equally true. There is no crime against children that is too dark to fight, nor worth every effort to expose. Ritual abuse is a war against our children, and there have been casualties. They are too young and innocent to fight for themselves. This evil practice flourishes underground in Utah today, and our defenseless children are left numb by their parasitic and well-disguised sadistic perpetrators. The expense for my healing journey has cost the state of Utah hundreds of thousands of dollars. One study estimated that each rape costs approximately $151,000. So knowing that with ritual abuse, an individual will often be raped hundreds and hundreds of times, you can imagine the astronomical expense. and this can be greatly decreased with strong legislation, prosecution, education, and public awareness. Our children are not freebies. We are fighting in defense of our children today. Thank you once again for your significant efforts to uphold human dignity and for your bipartisan commitment to ending sexual exploitation in all of its forms, including ritual abuse. I trust that you will continue to stand united in this vital cause. My hope is that everyone who has vested interest in protecting children will strongly endorse this bill. Let's shatter the silence on ritual abuse in Utah. Thank you so much.
Thank you, Ms. Baldry. Is there anyone else that would like to comment on this bill? Okay, there is someone online. Caleb Rule. I'm guessing I may have butchered that name. Caleb Rule. Caleb, if you'll come on camera, we'll give you a couple minutes to provide your witness as well.
Thank you. Can the committee hear me?
Yes.
Okay. Good morning. My name is Caleb Prue, and I'm a practicing attorney here in Utah. I'm here because it's important that the committee be exposed to more than just one perspective on the matter of ritual abuse. It's critical to say that nobody opposes criminalizing or enhancing the penalties for child abuse because they approve of such abuse. But the legislature must guard against well-intentioned but ill-considered laws that ultimately cause more harm than good. I see the danger of this legislation is that it will validate false allegations of ritual or satanic abuse, and law enforcement resources will be wasted as a result. I think it's fair to say that no one today looks upon the Salem witch trials as positive pro-social events. The more recent moral panics about satanic or ritual abuse in the 80s and 90s remain controversial, but an objective review of the evidence that we now have demonstrates that these moral panics always leave a devastating wake. Why do such false narratives cause such harm? The answer is that the vast majority of satanic or ritual abuse allegations are not and can never be validated as credible because there is no evidence. In the 1990s, the Utah State Task Force on Ritual Crime undertook a 2-year investigation of similar allegations that were proliferating in the state at the time. And after investigating about 125 cases, the task force ultimately concluded that only 2 cases could be substantiated. One of these cases couldn't be prosecuted due to the statute of limitations, and in the other case, a dozen members of the Zion Society cult in Ogden were convicted of sexual abuse of children under criminal statutes that still exist on our books. So that's 2 out of 125 cases and a validation rate of less than 0.02%. Despite this and other similar evidence, the belief that there's an epidemic of ritual or organized satanic crime persists as folklore. So I'm speaking out against the bill. It's a solution in search of a problem, and I urge the committee to not draw away law enforcement resources from the known and substantiated issue of non-ritual sex abuse. Thank you.
Thank you. Okay, I don't know if there's anybody else, so we'll bring it back to the committee for further discussion or action. And we don't have a quorum, so Representative Abbott will come back to you when we have a quorum, especially in the Senate. So
going back to the ritual abuse amendments, I make a motion that we favorably recommend that bill.
okay, so the motion before us is to favorably recommend ritual abuse amendments as a committee bill. Discussion to that motion. Okay, seeing none, we'll place that motion. All in favor, say aye.
Aye.
Aye. Any opposed? Okay, that motion passes as a committee bill, so thank you.
Our very next agenda item is item number 5. This is juvenile court procedures amendments bill, and we'll discuss draft legislation. We'll start again with Jacqueline Carlton, and then I'm going to turn the chair back over to Representative Hawkins because this is my bill. So, Ms. Carlton.
Thank you. I'm Jacqueline Carlton, and again, I'm one of the staff attorneys for this committee. I'm not actually the drafting attorney for this bill. But I wanted to just kind of give a brief introduction into this bill because the committee opened this bill as a result of a staff presentation that I gave back in May on cases where Utah appellate courts have asked the legislature to address a statutory issue. And so the case that kind of prompted this bill was called In Re ASGR, which was a child welfare case. And in that case, there were two parents that had gotten divorced, and at issue was the mother's custody over the child. And there was a DCFS investigation and everything. And kind of the outcome of that case was that the juvenile court decided to award permanent custody and guardianship to the father. So it didn't terminate the mother's parental rights. But what was at issue was kind of the options that the juvenile court has in these kinds of situations. And so under the statute, a juvenile court, if they decide not to return the child to a parent's custody, they can either terminate the parent's parental rights, they can allow for adoption of the child, or they can award permanent custody and guardianship to another individual, which is what they did in this case. Something that the mother pointed out maybe was that there should be a fourth possible option, which is just to enter a custody order and let the custody and parent time statutes for divorce cases govern that order. The Court of Appeals said that was not an option for the juvenile court under the statute, and they thought it was odd kind of in these situations where you have two parents and one parent whose parental rights is not being terminated, to kind of have this award where we're just awarding permanent guardianship and custody to the other parent. And so they kind of proposed maybe the legislature look at this issue and maybe provide another option for the juvenile court. And with that being said, I'll turn it over to Senator Weiler to explain the bill.
Thank you. I don't know how many of you remember this discussion back in our May interim, but I remember it well because I was virtually online and I had earphones on. I was riding a city bike around London during this discussion, so I just had this flashback to that good memory. So we opened this bill in May. The reason that the case is called In Re ASGR, it was a hyphenated last name, is because the juvenile courts, they don't want to reveal the identity of the children in a published decision, so they just use their initials. I just didn't know if everybody knew that. And the bill reflects input. We create a family law working group that included Michael Drexel from the courts, as well as attorneys Brent Hall, Scott Weiser, Deb Wood, and Dave Fury. I'm not sure if I'm pronouncing his last name correctly. Representative Grecius also reviewed the draft legislation as I did. The bill specifies that if both juvenile and district courts have cases involving custody or guardianship of the same child, and after the juvenile court terminates their reunification services and enters an order of custody and guardianship, then the district court will still have ongoing jurisdiction over that order. That's really an important gap that we need to kind of bridge in the family justice court system. It also creates a specific mechanism by which a parent whose reunification services are terminated and who is not awarded permanent guardianship and custody may petition the court for reconsideration after a material change of circumstances if the guardianship and the custody were awarded to the other parent. And, a material change of circumstances could be a death or a debilitating injury. Maybe they're still alive, but they're in a coma of the other parent. It could be a lot of things, but there are things that can happen where, if a few years have passed, then the parents whose rights were limited or terminated might come back into the picture. Do we have Mr. Drexel here in the room? I don't see him. So, Representative Hawkins, that will conclude my presentation.
Thank you, Senator Weiler, and thank you, Jacqueline. I'm not seeing any lights from the committee for discussion. Okay. Anybody from the public that wants to comment on this? Okay, we'll bring it back to the committee for a motion.
Okay, I'll make that motion that we favorably recommend Juvenile Court Procedure Amendments version 4 as a committee bill.
That motion is in order. Discussion to that motion. Representative Lisenby?
Thank you, Mr. Chair. Thank you for your work on this, Senator, and I'm in full support of this policy. I think it's a good move, so thank you for all your work.
Thank you.
Thank you. Okay, the motion before us is to favorably recommend Juvenile Court Procedure Amendments version 4 as a committee bill. All in favor say aye.
Aye.
Aye. Any opposed?
I would say it has to.
That was an aye.
Okay.
I heard it.
All right. We'll rule that motion passes unanimously. Thank you, Senator Weiler, and back to you.
Thank you, Representative Hawkins.